Well, hey there, folks. Bill O'Leary coming to you this day to answer the question, estate planning when one spouse is not a citizen. Okay, so in this video, you're going to learn why estate planning needs to be done more carefully when one of the spouses is not a U.S. citizen, and ways for a married couple where one spouse, again, is not a U.S. citizen to achieve the same tax benefits that citizen spouses can. So introduction, this is Bill O'Leary. My firm is Legacy Planning Law Group here in Jacksonville, Florida, and I do estate planning, elder law, and probate and estate and trust administration. That's all we do. We focus on that. So let's jump right in. All right. So these days, look, it's not uncommon for a U.S. citizen who lives in this country to be married to a non-citizen. And when a U.S. citizen marries a non-U.S. citizen, estate planning issues become more intricate. First, let me get one question out of the way that I get asked a lot. Can non-citizens inherit property or assets? And the answer is yes. Non-citizens can inherit assets just as citizens can, okay? So when you make your will or your living trust, or you name beneficiaries of, let's say, your retirement accounts or life insurance, there's no prohibition on naming your non-citizen spouse as a beneficiary. The issue of non-citizen spouse planning doesn't have to do with sort of being able to legally transfer assets to that spouse at death. You can. It has to do with taxes, specifically estate and gift taxes. So first, let me explain to you how the tax system works at death when the surviving spouse is a U.S. citizen. At the first spouse's death, there's no estate tax. This rule is called the unlimited marital deduction. Any taxes that might be due at the first spouse's death are deferred until the second spouse's death. Now, this marital deduction, this great rule, does not apply when the spouse who inherits isn't a U.S. citizen. You see, even if the spouse, the surviving spouse, might be a permanent U.S. resident, non-resident alien, or resident alien, I should say, the law is designed to allow the IRS to get its money at the first death when there's a non-U.S. citizen spouse. The government doesn't want, someone who isn't a citizen to inherit a large amount of money, pay no estate tax, and then leave the country to return to his or her native land beyond the jurisdictional reach of the U.S. court system. By the way, just as an aside, the marital deduction may not matter that much if the size of the estate is not large enough to be over the estate tax exemption amount. But knowing how Congress would love to lower the exemption and ensnare more estates in the estate tax to raise more tax revenue, couples where one spouse is not a U.S. citizen need to be especially careful and plan properly. So for these couples, there are two strategies that can be used. One is that the non-citizen spouse can become a citizen, okay? And so as long as that process of citizenship is completed by the time of the deceased spouse's federal estate tax due date, okay? And so doing that will let the surviving spouse use this unlimited marital deduction. But here's the problem with that solution. It's often not a realistic one, because if the non-citizen spouse waits until after their U.S. citizen spouse dies to start that citizenship process, there's no way there's going to be enough time to get it done, not even close, because the estate tax return is due 9 months after death. And even with sort of a guaranteed a 6-month extension, that only takes us out 15 months from the date of death. There's no way the citizenship could be obtained in that time frame. It normally takes much longer than that. In addition, even if it could be pulled off in that quick period of time, the non-citizen surviving spouse may not want to become a U.S. citizen for various reasons. Again, even if they could. For example, maybe becoming an American citizen may require them to renounce their home country's citizenship, which could affect their right to own property in that country. Let's talk about the second solution, which is much more viable and is done quite often. And that is establishing a trust, a certain kind of trust called a qualified domestic trust. We call it a QDOT for short, QDOT. This solution is a way to ensure use of the marital deduction. The benefit of a QDOT, again, is to enable the non-citizen spouse to use this unlimited marital deduction that's available to U.S. citizen spouses. And it's a way for the government to know that the non-citizen spouse won't flee the country with inherited assets without paying any state tax. So a QDOT is normally created as part of the citizen spouse's revocable living trust. And the way the trust works is that the non-citizen spouse is the sole beneficiary of the trust while he or she is alive, and there can't be any other beneficiaries during that lifetime. The surviving spouse is entitled to receive all the income from the trust. If principal distributions are made from that trust, they're subject to estate tax at the time of distribution, and this tax is computed as if the distributions were included in the U.S. spouse's, deceased spouse's estate. The same is the case for any assets that are remaining at the surviving spouse's death. So in other words, the QDOT arrangement only defers the federal estate tax bill. It doesn't reduce the amount that ultimately must be paid to the U.S. Treasury. And after any estate tax is paid, the remaining assets in the trust are paid out to the deceased U.S. spouses, the first spouse to die, to their designated beneficiaries as set forth in the trust. The trustee, the QDOT rules say that the trustee must be a U.S. citizen or a U.S. bank or trust company. And in fact, if the trust assets exceed $2 million, the trustee must be a bank or U.S. trust company unless some other requirements are met. Now, real quick, let me talk about, so I've talked about up till now, passing assets at death from one spouse to the other spouse, the non-citizen spouse. What about gifts between those spouses during life, lifetime gifting? If your spouse is a citizen, any gifts you give to him or her during your lifetime are free of the federal gift tax, okay? If your spouse is not a U.S. citizen, however, this special tax-free treatment for spouses is limited to, here in 2022, the number is $164,000 a year. That keeps getting bumped up, again, because it's indexed for inflation. But of course, if exemptions remain high, most people can use up their exemption amount for any additional gifts that are made over and above that $164,000 threshold. But again, we don't know how long these exemptions will last. The government is always looking for ways to increase taxes. They're hungry for tax revenue. Now, what about property or assets owned jointly between spouses where one spouse is not a U.S. citizen? This is often a trap. If the citizen spouse buys the entire property or asset with his or her own money, the government says that, in effect, a gift has been made to the non-citizen spouse, which is put on the title. A gift is made for half the value. The non-citizen spouse would have to prove that he or she helped pay for the property to avoid this deemed gift rule from applying. So if you'd like to know more about estate planning when one spouse is not a citizen and maybe how we can help, we would love to start the conversation and to make it easy for you, to encourage you to book a free 15-minute discovery phone call. Just go ahead and go to the bottom of this video. There's a registration link. Click on that, takes you straight to our booking calendar, or you can go to our website, legacyplanninglawgroup.com, and click on the blue button that says book your free call. Both ways, again, takes you to our booking calendar. Pick a day and time that works for you. So this is Bill O'Leary on behalf of everyone here at my firm, Team Legacy. Go make it a great day and a better world.